Hi, my name's Paul Taylor, and I have a website called fightwcb.org. I've been fighting Ontario's workers' compensation system and connecting with injured workers across Canada for the last 25 years. I've also learned a few things about the law and fighting workers' compensation. This is because I've become a licensed paralegal within the province of Ontario. So I decided to create some instructional videos to teach others how to fight for your rights as a Canadian, and even those that are not Canadian citizens or landed immigrants. And those are the ones that were temporary foreign workers who came to Canada for a better life temporarily and got injured, then got shipped back to their home country. At any rate, I decided instead of doing my first video on my work accident and the horrors of me dealing with Ontario's workers' compensation system, instead I decided to explain how you might be able to fight for your rights, specifically your charter rights, in any appeals or arguments you make before the compensation system. Now, unfortunately, I'm only speaking about Ontario in this, so you might have to do some homework in your home province or territory to find out such things as if you can raise that argument, a constitutional question as it were, in your province before the border tribunal. But not to worry, if you can't, you can always bring that at a later stage before the court or earlier before the court. And I'm going to try and explain that later on as I go in, but not to some great detail, unfortunately, because that's what they call as out of the scope of a paralegal. It's more in lines with a lawyer. But I will, in later videos, explain what I've done in the courts as an injured worker and a self-represented litigant. So in this video, I'm talking specifically about how to raise a constitutional question before an administrative board, tribunal, or commission within Ontario. Ontario allows for these to be done in its administrative boards and tribunals, and more specifically, the Workplace Safety and Insurance Board, which is Ontario's Workers' Compensation Board, allows it, as does the tribunal, the Workplace Safety and Insurance Appeals Tribunal. Why raise a charter question or a constitutional question? Simple. You're protecting your rights as a Canadian citizen. Even if you're not a Canadian citizen and you were injured in Canada, the Charter and the Constitution does apply to you with some limitations. I believe the only one would be Section 6, right of mobility. But just because of that doesn't mean to say you don't have rights as a person. You do. And it's important to know what your rights are. The disturbing thing is most Canadians don't understand or even know of the Charter of Rights and Freedoms. Jokingly, they'll say when they want to plead the remain silent is they'll say, I take a fifth, and I jokingly reply, unless you're referring to whiskey, there is no Fifth Amendment in Canada. You're talking about your charter rights and your right to remain silent, which is your legal rights, and I'm going to talk about those later. Probably one of the most important changes that occurred with Canada's Constitution from 1982 was the Supremacy Clause, is what it's called, and that's Section 52 of the Constitution Act, specifically of 1982. And it basically says that the Constitution and all its parts are the supreme law of Canada, meaning no other law can override it. Well, there is some exceptions, and I'm going to talk about that later, regarding the Charter. And I'm sure as a Canadian, as I am, I think you'll be annoyed in how it was created. First, let's go back in time to 1867, or just before then. This was just after America had won the Civil War, or not the Civil War, sorry, the War of Independence with Britain. This is when the Prime Minister approached Queen Victoria and said, hey, you know what, you could prevent this from happening again in Canada and allowing us our own constitution. So they drafted the constitution, and the amazing part is you can see how it's written is the provinces of Canada, being Upper and Lower Canada, Nova Scotia and New Brunswick, express their desire to become one dominion, and so on and so forth. Now what I did too was in this slide, and I'm leaving it on for a minute, is I actually posted the website link of the actual constitution. And when you go to this website, you click on the table of contents and you'll see how it's very effectively presented. The federal government does do a very good job of organizing the documents. These documents, the constitutional documents, you can actually reference in legal arguments in that. So that's the website, and you'll see that it lists this Constitution Act of 1867 as well as the 1982. And within the 1982, it also lists the Charter of Rights and Freedoms. So everything is there and it's broken down very nicely. The importance of Canada's Constitution Act of 1867. It is very important for three reasons. The first being, in two parts, is that it creates a separation of powers. The first is the powers of the Parliament, and second, the powers of the provinces or territories. This is really important because it spells out clearly what the provinces can do and what Parliament can or cannot do. And as you can see, I've listed the sections of the Constitution, so when you go to that website I showed you, you can actually see for yourself. And always, whenever I'm talking or giving these lectures or these videos, I really want you as an individual to learn for yourself. Never take my word for anything. Challenge it with respect and say, well, where is that? And I'm always happy to try and show people where it is. It's not that I'm saying don't believe me. I'm saying don't believe anyone in effect, and learn and see for yourself. It's very important to not just accept the word of someone. I mean, in some ways you do, but especially in understanding the law and your rights as a Canadian, oftentimes I come across people and they'll say, oh, you can't do that. Why? Oh, because the law says so. What law? Oh, the law. What do you mean, the law? And they never tell you. Whereas I like people saying to me, well, what do you mean, Paul? The separation of powers. And I'll say, oh, basically it's section 91 and 92 of the Constitution. So you go to the website, look it up, and you'll go, oh, okay, I see what you mean. And you could turn around and say, oh, no, Paul, you're actually wrong. It's this and this. And I respect that. That's called proper argumenting. You're presenting facts, and then you're presenting your final point, or your therefore, as it were. And that's very important. Just to turn around and say, it is because it is ridiculous. That's actually called circular reasoning, and what they call is a logical fallacy. And sadly, you'll find in my future videos when I talk about different things, the workers' compensation system tends to have a lot of circular reasoning or logical fallacies in their decisions and in their conduct. It's very disturbing. Probably the most famous one in my mind, or the most devastating, is when they think you're faking. Well, we think you're faking because we think you're faking. What? Yeah, they have no proof, no actual facts. They base it all on personal opinion. And in my opinion, is that in doing something like that, not only is it an error of law, but it's also, well, defamation. It's slanderous. They're accusing you of something that you didn't do, and they're causing you harm to your character as a person. At any rate, getting back to the third point is the judiciary. And the judiciary is extremely important, probably more important, well, equally important as the others. And that is what I want to explain with this is a government, especially a democratic government like Canada, it's broken down into three sections. You have within the elected body, you have the executive, which is Prime Minister and the cabinet and them, and their job is to carry out the laws. And then you have Parliament, or in the case of the provinces, the legislature. They create the laws. But the equally important part is the judiciary. And the reason why I think they're very important is because they not only protect people's rights, like for example in criminal law, if you've been harmed or whatever, the Crown presses charges and they oversee this, as well as in civil disputes and other issues. But more importantly, in their job, in my opinion, probably one of the most important parts is they keep the checks and balances of government. They keep the government in check, which is extremely important. Let's think back to the time of pre-World War II. Hitler seized power. Now, if Germany at the time had a very robust and strong judiciary, and somebody said, and a constitution of the people, as the Americans say, of the people, for the people, if they had that, and somebody went and said, hey, Adolf, you can't do that. People have a right. You can't get rid of the Reichstag. We have our right to do this, and then challenge it in the court. And if the government respected the court, then that would have stopped, and it would have stopped World War II. More than likely it wouldn't have, because then he would have just removed the judges. This is the lead in to dictators, and this is the power struggle that they do. But my point is a well-written and fair constitution and a fair judiciary will always protect the people from a dictatorship or a totalitarian regime. A totalitarian regime is basically a collection of dictators ruling the country. Within Canada's Constitution in 1982, and there's an important point I want to bring up. Many people raise issue about Britain's rule over Canada. They ruled it for so many decades and so many blah, blah, blah. No, actually, believe it or not, what happened is in World War II, America came to Britain's aid. That's what they say, and I mean, in many ways, they did. It was a global war. But one of the things that came out of World War II was the end of colonies. And Britain said, okay, fine, we'll give up the colonies. And they had said to their colonies like Australia, New Zealand, South Africa, Canada, you're on your own now, do your constitution, do whatever you want. It took Canada from 1945 or 1950 until 1982 to get it together and create their constitution. Part of the reason why was getting the provinces to agree on a written document of governance, which in my sense, it took Pierre Trudeau to say, well, to hell with you, this is what we're doing, and I don't care. In many ways, it was good because he busted the backlog, not backlog, but the problems with the democratic system. But there was another way, what I believe would have been more fair and true to a real constitution. My personal belief of a constitution is one that may have been written by politicians and parliamentarians or whoever, or scholars. But ultimately, to me, a constitution is not a constitution unless it's approved by the people. Because the difference is this simply, is that any law within Parliament is a law that was put into power by Parliament. What's the difference between a constitution and a law? Canada tries to say it's because the provinces and Parliament, the legislatures of the province and Parliament, created it together. Okay, that's a bit closer. But why didn't they just put it to the people and say, this is your constitution. This is your document that tells us how to govern you. Doesn't that make sense? In a taking a page from the American Constitution, wouldn't it then be of the people, for the people, to be governed of the people, Instead, that didn't happen. And that's what frustrates me about the Constitution, and I'll get more into this later, of the failings of our Constitution and of the Charter of Rights. It is a great document, don't get me wrong, but unfortunately it has some serious failings. One of them I'll talk about in a few minutes. But at any rate, The 1982 Constitution, what it did was Pierre Trudeau, as you can see in the photo, signed it with Queen Elizabeth. The photo is courtesy of the Toronto Star. And they signed the Constitution, and part of the 1982 Constitution gave us the Charter of Rights and Freedoms. Within that 1982 Constitution, it is broken down into several parts. Part 7, and I'm going to start from the top down. Part 7 is the Supremacy Clause. This is probably one of the most important parts because it says the Constitution is the supreme law of Canada, meaning any other laws of no force or effect. However, there is exceptions when we're talking about the Charter. It also provides another important part, which is the amending formula or the procedure to amend the Constitution. Again, like I said, very importantly, and I'll talk about this again, is there is nothing in there mentioning about the people and the vote to the people. The equalization and regional disparities section, which talks about, like, for example, if Ontario is the economic engine and Manitoba and, say, Saskatchewan are struggling, then they get transfer payments. And another very important part is the right of Aboriginal peoples. It is very important that they be recognized. And it's interesting because many people develop a hatred towards Aboriginals, or as I like to say, as Native people, because an Aboriginal professor told me saying Native is correct because we believe we're of the land. And I went, oh, that's wild. And it's true. But to me, they're Canadian as well as Canadian being Aboriginal. And the reason why I say this is because we've been many Canadians, and at least in my background, goes back hundreds of years, which means Aboriginal peoples and others tend to commingle, as it were. So there is DNA in many of us Canadians today. So when you hate Aboriginal peoples, in effect, you're hating yourself or part of yourself. So this is why I think reconciliation and this acknowledgement of the horrors of Aboriginal peoples needs to be acknowledged. But at the same time, too, our history is robust in many ways, and we need to recognize that as well. I think an inclusionary history is important. We shouldn't erase the past. We should acknowledge the wrongs of the past. That said, let's move on to part 1, which is the Charter, and probably the most important part of this video. I want to talk again a bit about the importance of Section 52, which connects everything together, including the Charter of Rights and Freedoms, and that is the Supremacy Clause. I've shown you 4 cases. There's many cases, but these are the most wow cases. For example, is R.V. Morgentaler in Canada. Abortion was ended, or the criminalization of abortion was ended with this case. Basically, the Supreme Court said that a woman has a right to control over her own body. And just a small point, I am not pro-life or pro-abortion. I'm right in the fence where it should be, like Switzerland, nice and safe. I would say to anti-abortionists that you can have abortion, but reduce it considerably by providing programs to people that become pregnant. Probably one of the most hypocritical thinkings of conservatives and American Republicans is to get rid of social programs. If a young, for example, teenage mother or a young woman becomes pregnant, her greatest fear is financial cost of raising that child. Most children are raised in destitution and poverty today. This is something that they're being hypocritical because they're increasing poverty by not allowing abortion. However, if they had a great, robust program, social program, and acknowledgement, oh, if you're pregnant, it's not a sin. It's not a horrible thing. If you're a teenage mother, we're not going to chastise you. We will help you raise the child. Convince them to do it. Don't treat them like criminals. And then you won't have to worry about fighting the abortion laws or anything else. And at the same time, you're protecting the moral rights of individuals. The next one I want to talk briefly about is Carter v. Canada. This was a landmark decision because it gave people the right to assisted suicide, meaning that if they're in agonizing pain and their life is just pointless, that the Supreme Court recognized this. Now the government has been tinkering with it, and there is issues. And on the con side, meaning the negative side, is many would feel, well, then what if your condition is curable, meaning conservative government can cut back social programs and healthcare and causing your condition to become so unlivable that you just want to die. So then it becomes literally like Soylent Green movie with Charlton Heston, where we're killing off people that are not well, or Logan's Run, the older. This is a big fear, is, as they say, trimming the fat of society. And it's a legitimate concern. And again, this is why to allow it is the right thing. But also, to counter is you have to have proper and fair social programs, like a workers' compensation system that works and doesn't discriminate against people with pain, especially chronic pain. Another case that's interesting and powerful was R.V. Jordan. This shocked the very foundation of Canada's justice system. It wasn't that I found it funny, I found it very intriguing to watch the aftermath. The courts were being set up quickly, and judges were being hired rapidly, because what happened was the Supreme Court put specific limits on criminal cases. If your case is what they call is not a minor charge, but a non-complex case, meaning what they would call under the criminal code is summary conviction and provincial offenses stuff, it's 18 months from charge to trial is what the Crown has to bring it. Now, if a defendant says, I need an adjournment, then that time of adjournment, the clock stops ticking, meaning it could be 20, 30 months. In the cases of the more severe charges, I believe it's 36 months or 24, I can't remember. But you can look it up if you're curious as to the time limits of these charges. And like I said, again, the more important one that affects most people is the lesser one, which affects criminal charges like assault, stuff like this. Those are charged under summary conviction. But more importantly, it's the provincial offenses charges, Highway Traffic Act, and wrongful convictions of workers' compensation cases where they'll claim you failed to report a material change, or they're accusing you of fraud. And believe me, it does happen regularly. The final one that I want to talk about sort of connects with the Carter case, but doesn't. It actually strengthens the Carter case because the Supreme Court recognized that injured workers have a right to compensation for chronic pain. Ironically, this occurred 12 years prior to Carter case. So it kind of, in my opinion, set it up in a good way. So we don't reach that stage of cutting the fat of society, you know what I mean? Because that is not only immoral, unethical, in my opinion, it is unconstitutional, no matter how you spin it. People requesting suicide because of a failed system is not the answer. I just want to talk about the hierarchy of the Constitution, specifically the structure of how decisions and things are done. The Constitution, as you can see, sits at the highest. Human rights legislation, this is something that's interesting and I want to talk about very briefly, is that the Supreme Court, or the courts, including the Supreme Court, recognize human rights legislation as quasi-constitutional. Meaning that is like that of the Constitution, and the reason why is because the human rights legislation has what they call is like a supremacy clause or a primacy clause, where it sits above all other laws in the province, or in the case of federal, in the federal. Now, for example, in Ontario, I believe that's section 47. The problem with it is it does say, though, that the legislature can put the Human Rights Code aside in certain laws. So it's not really a supreme law, because it can be overridden or notwithstanding, as they say. they have to put a section in, like, for example, with workers' compensation in Ontario, the issue of age doesn't apply. And that's specifically the reason why they do that, is because they look at your body when they're giving you a permanent impairment award for a disability, and they say your body ages. So as a result, you receive less money. So this is discrimination based on age, but they say it's justified. I don't. I think that, you can have somebody that's 50 years old and have an extremely healthy body, and somebody that's 20 and completely toxic. So it really isn't on an individual case, but again, the government likes to be simplistic. The next is the written laws and legislation within the federal and provincial government. Canada is unique in a way because the federal doesn't trump the provincial laws. It depends on the jurisdiction of the issue. So with workers' compensation, presently it's provincial. So you deal with the provincial laws. Interestingly enough, in our charter challenge, we're challenging the jurisdiction of workers' compensation in that it should be federal. And I'm going to talk in another video about that as well. Then there's written policies, procedures, and finally there's written decisions of the courts and of the tribunals and boards. Now, within workers' compensation, this is a Latin term called stare decisis, meaning you have to follow common law. Now, the boards and tribunals will say we don't have to follow common law. What they're talking about is they don't have to follow their own decisions of the board or tribunal, but they must follow the decisions of the higher courts. The next thing I want to talk about is the amending of the Constitution. How is this done? And it's done in a very complex way of a percentage of the population within Canada. The legislatures agree with Parliament. But what was interesting was there was 3 attempts, and that was the Meech Lake Accord, the Charlottetown Accord, and the Quebec referendum. The latter two actually were put to the people to vote, which was interesting. Charlottetown Accord, I remember I voted on it and I said no, because half of it was to be completed later. It's like signing a blank check or signing a contract that hasn't been completed. And that was and everybody I talked to, that was their biggest concern. But getting back to what I said earlier, which is that within the amending formula, in nowhere does it include the people of Canada. And it's kind of like, what? Yeah. Again, like I said, there's part 3, which is the equalization and the rights of Aboriginal people. Let's move into part 1, which is the Charter of Rights and Freedoms. This is composed of several sections. I believe it's section 1 to 34. Section 1 is probably one of the most important sections, believe it or not. It provides, as you can see there, that basically it's like a notwithstanding clause or an exemption. So you can have rights so long as what you do is when you go to argue a point, so say for example you say that the Workers' Compensation Act or the conduct of the Workers' Compensation Board or lack of action of the Compensation Board infringed your section 7 or 15 rights or 12 or whatever. They then, the board or whoever's deciding it can say, yes, we agree there was an infringement. However, then what happens in this, the government can then argue and say, yes, there is an infringement. However, we submit that that infringement is justified in a free and democratic society. And as you can see in the Oakes test, that justification must be proportional, it must be in specific meaning, it must be connected to the objective, it must be minimal in impairment, and proportional between the infringement and the objective. So there's a specified reasoning of this. And it's important to note that this applies to any section of the Charter. So in effect, one could argue that your right to life isn't really an absolute right, because they can argue that it can be infringed. It hasn't been, but it could be, and that's disturbing. I just wanted to reemphasize the Section 1 in connection to workers' compensation legislation, specifically and most importantly what's called as the historic trade-off. This is where injured workers get a right, a guarantee to workers' compensation, and in return they lose the right to sue their employer. So as it says basically is that the former, the employer, are protected. In that case it says that section of law, but you just insert the section of any province against the possibility of being sued in tort civil law for work-related injuries. And the latter being workers are guaranteed a reasonable amount of compensation for such injuries. Now, the problem with this is that what I argue is that presently, since 1990 in Ontario and pretty much all the other provinces, is that since 1990 onward, the legislatures changed the law and said, yes, injured workers get a reasonable amount of compensation. However, they have to return to work. They have this, what I call as forced return to work program. The board decides if the work is safe and suitable. Usually, they change the wording from safe and suitable to modified work. So that way, because if you don't hear the word safe, you can't say, well, that's not safe. And if you don't hear it suitable, then that's not suitable. So they use this trick. But getting back to my point, the board uses this to force you back to work with this legislation. So in theory, if a worker is injured on Monday, the board says you have to get back to work Tuesday, then they didn't get a reasonable amount of compensation for their injuries, did they? So in my argument, in my position on this, then in theory, in an agreement as this, where you get one for the other, there is no one for the other. You just lose your right and you don't get a right in return. Because a right is a right, meaning it's not a privilege. It can't be taken away. And in this case, it has been. So therefore, if you've lost your right to compensation, then equally and logically, then the employer has lost their right to being sued, their right of immunity. It's a reasonable argument. The problem is trying to convince a judge in a court of it, and I am very skeptical, as most injured worker advocates are. The courts seem to be very bitter towards injured workers, and they have been since the beginning of time. Another topic I'll bring up in another video of the history of workers' compensation through the years prior to 1896, when in Ontario it's called the it was nicknamed the Employers' Liability Act, but it was actually the Workmen's Compensation or Workmen's for Compensation Act or something of 1896. What the law did was remove the employer common law defenses. But still, the courts were very aggressive towards injured workers in not giving them compensation. I now want to talk about the historic trade-off with Section 1 again, specifically with cases. The two cases that stood to mind in reviewing case law on a constitutional basis was Ricardo O'Brien, where the Ontario court found there was actually a Section 15 breach, as I was saying. However, they said it was justified under Section 1, like I was telling you. This was also the case in Alberta with compulsory coverage for native reserves, meaning that the compensation board said, no, it is not a Section 15 infringement because it's justified under Section 1. This is the end of part 1. I wanted to break the videos down into smaller chunks, and we're just past half an hour now, and I hope you don't mind me doing it this way. So hopefully you'll be interested, and don't forget to check out part 2. Thank you.